Hi, I'm Emily, and I am here with Maya Murphy's attorney, Eva Marie Franco Fox. Attorney Fox practices at Maya Murphy's Westport, Connecticut office and is admitted to practice law in both Connecticut and New York. My question today for Attorney Fox is, my fiance and I both agree that we want a premarital agreement and on what terms to include in it. Can we use the same lawyer to prepare our agreement?
There is no law in the state of Connecticut that prohibits parties from consulting with the same attorney or otherwise retaining the same attorney for the purposes of drafting a contract, particularly a prenuptial agreement or a postnuptial agreement. Often we see parties go to a mediator to work out some type of agreement and therefore have the mediator draft the agreement. Parties can even come to an agreement on their own, privately within their own homes, just having discussions, and then go to an attorney who will jointly represent them and memorialize the agreement that they came to. While there's no prohibition on this, it is important for the parties to understand that in Connecticut, they both must have the opportunity to consult with independent counsel, meaning their own separate attorneys that only represent each of the respective spouses. It doesn't mean that they need to actually consult or retain their own attorneys, but they need to have the opportunity to do so if they wish to. What's even more important for parties to know is that it really is critical that they do consult with separate counsel to the extent that they're employing a joint attorney or the other side's attorney to draft the agreement. This is because a joint attorney or an attorney that represents your significant other does not represent you. They can't advocate for you, they can't represent your interests. Any information that you provide to them is not going to be kept confidential. And so, therefore, it's really important to ensure that your interests are protected and to make sure that the agreement doesn't have any unintended consequences that you're unaware of just simply because you didn't consult with your own attorney. In Connecticut, for example, waiving alimony in a dissolution is essentially a permanent waiver. You can't come back 6 months later, a year later, and say, well, I'm struggling. I thought I could support myself, but I can't. I need spousal support. In Connecticut, if you've waived it at the time of dissolution, it's a permanent waiver. So a party may not realize this. They may waive alimony thinking, well, if it doesn't work out, I can come back to court and I can ask for alimony. In Connecticut, it doesn't work that way. And perhaps a mediator or someone who's drafting the agreement for you doesn't tell you this, right? They don't have an obligation to advocate for you or to represent your best interests. They're simply memorializing the terms that you've reached with your significant other. This kind of situation where you're now which results in a permanent waiver of alimony could be avoided if you had simply consulted with independent counsel to ensure that you really understood the terms of the agreement and that the terms that you reach with your significant other are properly reflected in the agreement, but B, that there are no unintended consequences of the terms of the agreement that you're unaware of. So it's important to consult with independent counsel and ensure that even if you have an attorney drafting the agreement, that your independent counsel can ensure that your best interests are protected.
Attorney Fox is available 24/7 and can be reached by calling 203-221-3100. You can also email Attorney Fox at efox@mayalaw.com, and please visit mayalaw.com for more information.